ICE event for our latest report, ICE Out, Mapping and Resisting Local Law Enforcement Collusion with ICE in Massachusetts. We released this report at a time when there is widespread fear in our communities here in Massachusetts as federal immigration enforcement has shifted from the border into our local communities, unfortunately aided by local justice system actors who cooperate with and enhance ICE operations. While Massachusetts has legal precedent prohibiting state and local authorities from holding individuals solely on civil immigration detainers, significant communication, surveillance, and information sharing pathways remain legal and active. Through more than 90 public record requests submitted to agencies across the Commonwealth, our team at CfJJ found that local institutions routinely collaborate with ICE, often acting as force multipliers for the federal government. Today, we will discuss the scope of this collaboration, how it undermines trust in our public institutions, disrupts legal proceedings, and weakens democratic accountability. And we will propose recommendations for how to address these issues. These recommendations are timely as our legislature is actively considering policy on immigration issues, and we hope to ensure that whatever emerges from Beacon Hill is something that truly protects our immigrant friends and neighbors. Quickly, a few housekeeping matters. We're going to mute everyone who isn't presenting. We will have a Q&A section at the end of the presentation, but if you do have a question, please feel free to type it in the chat during the presentation and we will get to it, or simply use the raise hand option once the Q&A portion of the presentation begins. Lastly, the report ICE Out is up on our website at www.cfjj.org/ICE-out. So please feel free to check that out. And we will also have a recording of this event on our YouTube channel later this evening. With all that being said, I now would like to pass the microphone over to the report's author, Josh Dankoff.
Thanks so much, Leon, for the introduction, and thank you everyone for being here. It's a real pleasure to see some familiar faces and also to meet new people. My name is Joshua Dankoff. I'm the Director of Strategic Initiatives at CfJJ, and one of my roles is to do research and help fill in gaps here to help us in our understanding of what's happening in the child serving systems here in Massachusetts. If you're not familiar with CfJJ, we're a 32-year-old organization as a nonprofit advocacy organization working in the to improve the juvenile justice system here in Massachusetts. We look at the entire system, right? The juvenile justice system, but also other child serving systems, including child welfare in schools and intersecting systems here, including the immigration system, to ensure that and try to make sure that we have systemic statewide reform to achieve equitable youth justice. So our agenda for today, I'm going to present our report methodology, findings, and recommendations. We'll have some comments from our colleague at Mira, and then open up for Q&A. So first, I just want to set the stage nationally, right? We are at a moment of significant democratic backsliding, using the term that Steve Levinsky at Harvard Political Science has used, that the US is not currently a democratic system, but rather a competitive authoritarian system, right? So we still have competitive elections, but the regime is doing all it can to undermine elections. And one of the ways that it is acting in an authoritarian manner is through detaining tens of thousands of immigrants, including killing dozens of people in immigration detention, and killing, as we saw, at least 6 protesters, including 2 very high-profile cases in Minneapolis earlier this year. Just want to say the civil liberties and constitutional protections that we've generally have here in the United States have been cast aside, and that we know that the immigration enforcement has moved away from borders into our communities, and that the Trump administration is more and more labeling larger populations of people as deportable and even questioning birthright citizenship. Um, Here in Massachusetts, we do have a case, Commonwealth versus Lunn, that does prohibit local and state authorities from detaining a person solely on the basis of a federal civil immigration detainer. A detainer is a request from the federal immigration system to hold on to a person. But the law still allows a wide range of communication and information sharing and collaboration between our local system and our federal immigration agents. And that's what we're going to be looking at today. But we know that communication and information sharing can and often does lead to detention or deportation, and that this undermines the core due process principles here that we know of, including a presumption of innocence for someone who's accused of wrongdoing, an opportunity to be heard and defend oneself, and the right to an attorney. And that's just talking about the due process concerns for people who are accused of wrongdoing. But we also know that people who are witnesses or family members of accused have been detained and taken into ICE custody as well. For CfJJ, our name, Citizens for Juvenile Justice, the word citizen is in our name, but just to say, our population is people in the Commonwealth of Massachusetts, birth to 25, regardless of citizenship or immigration status. And for us, the arrests in May and October of 2025 of 15-year-olds in Chelsea and then 13-year-old in Everett, who were arrested by local police and then taken straight into ICE custody from the police station, was a real departure from past practice. And really, for us, was the trigger that we needed to pay attention to this. This implicates the agencies who are involved in juvenile justice system, and we needed to pay attention to this. So I'll give away the key takeaways here. So our key question was, and I just want you to be thinking about this throughout today, thinking about our juvenile and criminal legal systems today. Who should decide when information goes to ICE and under what circumstances? And if you we I want we're going to be talking in some detail about the police and sheriffs and court and information flows sort of between those agencies and ICE. But just as this overarching question, who should be able to decide when information goes to ICE? And a key couple of key takeaways that we know is that from what we've seen in our research, and I'll go into detail, most municipal, county, and state institutions here in Massachusetts that make up the juvenile and criminal legal system extensively share information with ICE, and many are doing open collaboration. There are some differences between agencies at the municipal level, but overall, there's a lot of information flows. There's very porous information moving from the local to the federal. And that this has a lot of negative impacts, not just for our immigrant neighbors who are frightened and who may be subject to detention and deportation. It also reduces trust in our local justice system and broadly co-opts our state level justice system into acting as a force multiplier for the federal administration's immigration policies. And this term force multiplier, I'm pulling straight from Peter Mancina's book, On the Side of ICE. And so a force multiplier is a local agency or person who is helping further that policy and doing things in furtherance of the federal policy that ICE can't do on its own. Briefly, the methodology for this report was primarily to get documents through public records requests to more than 90 agencies, about 60 plus police departments, all of the sheriffs and DAs here in Massachusetts. And most of the information in this report is based on this first records request. And we asked for three things. First, we asked for what are your policies, right? This is local level or county level policies that is instructing your police department or your police officers how they should and when should they communicate with ICE and when should they collaborate with ICE. And we also asked for the most recent communications between the department employees and ICE, and for any records concerning people who went directly from the custody of a police department or sheriff department straight to ICE custody. And if you want we will share also later today this whole presentation on our website. But these requests are available and public facing on Muckrock. So you should take a look. And if you find it useful, feel free to ask your own local entity what they're doing in this regard. More recently, we put in a second request asking for cell phone, landline, and text message communication between departments and known ICE phone numbers. We haven't really gotten very much substantively back yet, either because of timelines on that second question. So I don't have much to report there. We've also had a lot of conversations with advocates and information from secondary sources. So there's our methodology. And broadly, our findings are in two buckets. One is what information is flowing prior to arrest, um, and what information is flowing at the point or after arrest. So our first finding is that fusion centers, there are two in Massachusetts, the BRIC, Boston Regional Intelligence Center, and the Massachusetts Fusion Center, um, and automatic license plate readers can and do facilitate the sharing of surveillance information prior to arrest with DHS. And we know that there are DHS officials sitting inside Boston Police Department headquarters in as part of the BRIC. We know that there are some legal agreements that require BPD to provide DHS access to its databases, reports, and investigations. And there are also some limitations. BPD does say that they put up some limitations to not just share all of the information that they have through the BRIC. But the BRIC is collecting a lot of surveillance information and feeding it into a centralized place, and some of that information does make it to immigration, to ICE, and to immigration judges, for example, when people are facing deportation. We also know that license plate readers are used by some police departments around the state, and that the data is stored on databases and sometimes automatically shared with ICE nationwide. And now, while some local police departments may not directly share information and data with ICE, the license plate reader's use is really an indirect way for ICE to locate and detain people in Massachusetts. So this is all pre-arrest. We also have some concerns around the BRIC and other police departments' use of gang databases. I'm putting gang in quote here, that raise a lot of concerns, including concerns around racial disparity and a number of civil liberty concerns. So in some previous research that we undertook, we know that gang databases are documented nationally and in Massachusetts as having some very large racial disparities and at times are ridden with errors and disproportionately targeting Black and Latino residents. We, in 2021, put out a report looking at the city of New Bedford that highlighted that. And in 2022, the First Circuit Court of Appeals described Boston's gang database as an erratic point system built on unsubstantiated inferences. We have a number of concerns that the gang databases are subjective, racially and racialized identification, that there are a number of due process concerns in terms of people not getting noticed, they're put on a database, and having limited or no ability to challenge their inclusion. And we have concerns around data management and outdated records. Now, we know that the city of Boston has made some changes in recent years and reduced, for example, the number of people on the BRIC gang database. First, they changed the name and reduced the number of people by more than 50%. So we know that it's possible to reduce numbers, but we still have some fundamental concerns. And this will come up later. The reason we're bringing this up here is that the way information is collected and used prior to arrest, surveillance information and intelligence information, that can get people labeled as known or confirmed gang members can have real consequences for their immigration case later. And sometimes the gang identification is used as a trigger to allow information sharing from police to ICE. So it's important to note here. We've talked about it in the report, but there are also some grants to municipalities that raise concerns around requiring cooperation on immigration enforcement. I'm not going to go into detail on this. We talk about this a little bit in the report, but some of the requirements from DHS require 10% of funds, for example, to be spent, quote, supporting collaborations between state and local law enforcement and ICE. So we know the feds are not making this easy for local and state entities, but it's important to know this. And that a lot of towns that within the BRIC, the Boston Regional Intelligence Center, have stated that they cannot comply with ICE cooperation requirement. And this is just something to really pay close attention to. The final thing to talk about in this pre-arrest area does have to do with the police policies that I'll go into more detail in a minute here. We see that ICE collaboration is sometimes allowed and information sharing is allowed even before the point of arrest. One of the policies that we highlight, we're calling the Lexipol policy. Lexipol is a private company that has, they do a lot of things, but one of the things they do is write police policies and allow local entities to, sign up and use those policies. And the Lexipol policy, adopted by at least 4 places here in Massachusetts and probably more, allows officers to detain someone who's been lawfully contacted. So lawfully contacted is prior to arrest, and to contact ICE if they have a reasonable suspicion of a criminal immigration violation. So remember I said, what's the question we should be asking? Who, what entity, and who should be able to be sending information to ICE and under what circumstances? We have multiple police departments with a policy saying prior to arrest that their officers, first of all, they must have be investigating here whether and have a reasonable suspicion of a criminal immigration violation. And if they have that reasonable suspicion and they've lawfully contacted a person, that they can detain them. This sounds to me to be not in line with the Lund decision and is quite concerning. We know that ICE operates. ICE again wants to make this very easy for local police departments. They operate what's called the Law Enforcement Service Center, LESC, where local police can call for guidance if they, for example, when a detainer comes up. And we've seen one of the only. I think there's a lot of use of the calls going to the law enforcement service centers, but I can't prove it yet because we haven't heard back on that more recent public records request. But we have at least one confirmed call in early 2026 to the Law Enforcement Service Center from a Massachusetts Police Department. And ICE's A-crime system allows any agent to submit immigration status inquiries about people during arrest or for background checks. And just one last note here, this collaboration, Boston PD has an MOU, a memorandum of understanding with ICE that designates certain BPD officers as customs officers who can directly assist ICE in criminal immigration enforcement. So just to say, prior to arrest, these relationships exist. I'm now going to talk about things post, sort of at arrest and after arrest for some of the agencies later in the criminal legal system and the juvenile legal justice system. I think the biggest place where there's a lot of information moving from local to federal immigration authorities has to do with fingerprinting. And I'd say we'll talk in a little bit later about the Protect Act and some of the things areas where that aims to strengthen. One that does not touch fingerprinting right now. So we should really be paying attention to this question. The current fingerprinting process following arrest or at arrest at booking now result in automatic information sharing of a person's identity and their whereabouts with the FBI and therefore with ICE. So this chart here on the right-hand side sort of paints a picture that we have the arresting authority here, and there are different reasons why a police department might arrest someone, and their departments are only required to submit a fingerprint to the state police if it's a felony arrest under Chapter 263. They may submit a felony arrest, fingerprints for a felony arrest under Chapter 94C. Those are a lot of drug crimes, and they may submit fingerprints for any misdemeanor, which is sort of a less serious crime. In practice, uh, all of three of these, for felony and misdemeanor, almost all of the police departments in the states are submitting all of the fingerprints to state police. And once they're transmitted to state police, the state police automatically submits them to the FBI to do an identity check and a warrant check to see if they're out-of-state warrants. And once it's in the federal hands, ICE has access to it. It pings them, and ICE can show up and sort of go to a police department. So we saw, for example, in May of last year, when five kids were arrested on, well, some of them were not misdemeanor charges, but some on misdemeanor charges were taken into by ICE custody directly from a police station. The reason that ICE said, and the reason that at least the police department said at the time, was it's the fingerprinting process that alerted ICE to what's going on. That is a plausible explanation. And that is how the system does now work. But we also know that sometimes calls for or saying that fingerprinting process is how ICE learned about an arrest can mask other informal communication that would sort of a phone call or a text message between a police officer and ICE. So there are a few problems with this fingerprinting process. First of all, there are too many fingerprints overall, more than just required. And the police will always say, that this is a tool in our toolkit. Don't take away a tool in our toolkit. But this is an example where the law says may, and police are doing it almost every single time. So we should just really be aware of how laws and rules that are sort of meant to give some discretion here are used sort of in a maximalist way by policing agencies. And that the practice of fingerprinting that is taken for nearly all juveniles and adults for both felonies and misdemeanors will all go to ICE. Now, this is there's a balance here, right? A public safety balance to identify warrants from out of state. It's understandable, but we have to balance that against some of the known harms of sending a fingerprint, having that information go to ICE for people who have uncertain immigration documentation status. Our second finding within the post-arrest area has to do with police department policies. So while some of the police departments shared some communications, most of them did share policies if they had it, right? If they have a policy, it's easy for them to give us. What we saw is a large variation in what is written in these policies, with many of the policies requiring an immigration status check and sharing the results of those checks with ICE, and some policies even specifically allowing collaboration with ICE. So out of the 62 that we queried, a little under half have some policy that either allows or requires information sharing. 20 have no policy. 7 did not have a policy in place, but they either referred to their town or city's immigration ordinance or bylaws. And a few departments, 3 departments, have quite restrictive policies in terms of information sharing, and 4 still haven't responded, including the state police. Just saying. To start here, for those those policing agencies that either allow or require ICE, I'm going to highlight 4. The city of Quincy, in their General Order 3.08, requires an IAQ. It's an immigration alien query. And they require this for every foreign-born person who's arrested. So that includes a lot of U.S. citizens who might have been born out of the country. And their policy mandates notifying ICE of bail determinations and pending releases. All of these things are in addition to the fingerprinting process, right? And this is not required by law. This is not required by federal law. This is not required by state law. This is a police department choice to write this as a policy. In the city of Everett, they allow the word cooperation, even collaboration, and they allow individual officers who perceive it as it being in the public safety interests of the city of Everett to collaborate with ICE. And it permits citizenship checks for anyone with a questionable identification. The city of Holyoke runs an immigration query on all arrested individuals, not just foreign-born, everybody. And officers are instructed to contact ICE if any detainer or deportation order is found. And I've already talked a little bit about the Lexapol policy that allows detaining detention, police detention for even just lawfully contacted people. Now, those four are kind of the more, I'd say, egregious examples. Um, but the municipalities that I didn't just name um, will have some policy language that allows information sharing with ICE. So, for example, there's a fingerprinting policy in the city of Salem that says really all arrests, misdemeanor and felonies, should get fingerprinted. They now know, we all know that that's going to have information going to ICE. And while that their policy is not specifically around immigration, the impacts on people who are immigrants is quite strong. Um, and one thing we've seen in the records that we got back, and we talk a little bit about this in the report, is the sort of immediacy of communication between ICE and departments, right? Often ICE will ask a department for an old arrest report for someone that may be in their custody. And the timeline of responding, we see sometimes 15 minutes or within an hour, sort of this very quick response. Now, those might be public records, but I know that when I put in public records, I almost never get a response within 15 minutes. So we should just sort of think about these relationships that our municipalities are sort of if they're on the one hand saying they don't want to be communicating with ICE, but on the other hand are providing information very fast, that's quite concerning. There are a number of places that have no immigration policy, sort of no specific immigration policy, and are providing no guidance to their police officers as to when and whether to communicate with ICE. And what that means in practice is that it's just up, they allow the discretion down to each individual officer to decide. So remember my overarching question, who gets to decide? If there's no policy in place, the answer of who gets to decide is it's up to any specific officer on the ground to decide whether they want to share information with ICE. And this leads to really inconsistent and officer by officer enforcement and can lead to an erosion of community trust in law enforcement. There are a few places, and I'll just mention because people want to know, Boston and Lawrence are included in the list of places that don't have a specific policy, but do refer, or their policy will refer to a town or city ordinance. And there are a number of these Trust Act ordinances, sometimes called sanctuary city ordinances, that are in place. And this report does not do a full analysis of those. There have been some of those analyses elsewhere. We had more. There have been analyses of those elsewhere. These police policies was new, so we really focused on that. But just to say, those ordinances can be quite strong and can constrain what local police do. However, some departments, I'd say, appear unaware of that. And I have to call out Lawrence here, unfortunately, who, in response to our public records request, said, "Oh yeah, the city has something, but we are not even in. We don't even have it." So they didn't even respond with the Trust Act ordinance. And by claiming that they don't have it, it is quite concerning that they don't know what it is or what's in it and aren't following the rules in a Trust Act. And then there are a couple places that have quite restrictive immigration policies that are really constrain their police officers in communication with ICE. I'll just mention Bedford and Brookline, where they say specifically that no immigration status check is allowed, and that it needs to be identified by the chief, right? Putting in administrative friction here, not just allowing the officers themselves to make this decision, but saying that they need to sort of go up the chain of command to make that decision is can be helpful. And there can be some specific policies saying, that the reporting to the town administrator of any immigration raid that's going on, and any even requests we see in the city of Cambridge, requests from ICE for information need to be documented and then shared with city council. But unfortunately, these few policies are the exception, not the rule here in the policy in the Commonwealth. And even if a policy is restrictive, we may still have concerns, right? Some of the agencies, some of the municipalities listed here are members of BRIC and are still doing some of the broader surveillance and information collection. So it's just because there are municipalities listed here doesn't mean we don't have concerns. And just because a municipality is listed in the earlier one doesn't mean there might not be some good practices as well. So just want to say, if you're at the municipal level, I know this is very hard to see. It's tiny. It's in the report. So take a look at the report. Um, we did some comparison of some of the stronger or weaker language around some of these police policies, and questions that you could ask to your municipality would be, does the department check immigration status at the point of arrest and under what circumstances? Are city funds or department funds and resources being used for federal immigration custody? How does the department respond to immigration detainers? Are they in compliance with LUN? Knowing that fingerprints go to ICE, who is the department fingerprinting? Does it include all misdemeanors, all juveniles? And just broadly, what information can be shared with ICE and when? And how's the department respond if they know that ICE is in town doing some raids? So my takeaway message here is that policing policies are one area where municipal advocacy can be helpful, and it can be a constraint on what police do when they're out in the community. It's not the be all and end all, and it fits in the context of what the city ordinance is. It fits in the context of what the state law does. But given this very wide variation, it really calls for the legislature to step in and really say, what do we want here in Massachusetts for our values, given this wide variation? And we're glad they're starting to do that with the Protect Act. Some of the other data sources that we've seen is that police collaboration in ICE has a really large impact and a large negative impact. Some data from the Deportation Data Project identified 210 ICE arrests in Massachusetts since January 2025, when the sort of the location of the agency where the person was arrested from was identified as a Massachusetts police department. And so the top numbers here include Lawrence, Boston, Lynn, and Milford. And while I don't have the names of the people here, just to say that's different. When we sometimes heard in the testimony for the Protect Act that the police are really not interested in doing immigration enforcement. And then when we see that that people are being taken into ICE custody from 32 different police departments, that tells a different story. And we also saw that these police policies matter. In June 2025, Tewksbury Police Department had an individual whose bail was posted, but they looked at their policy, which was the Lexipol policy, and then there was a ICE detainer, and their policy said, yeah, we can hold on to him. And they held on to him, and he was taken into ICE custody. So this is not these policies absolutely do matter, and the practices are quite different. We also know that when there's research out there that's cited in the report that when people in the immigrant community fear that the police are contacting or trigger deportation, that crime reporting drops, and that really has a negative impact on public safety for all of us. The final finding here goes a little bit later in our legal system and talks about both things happening at the trial court. Oh dear, I didn't capitalize the words trial court. Well, the trial court is a noun, a formal noun that should be capitalized. The Massachusetts trial court and also our carceral system, including the sheriffs. I'll start with the sheriffs. Most sheriff's departments are sharing information with ICE and are proactively alerting ICE before people with detainers are released or go to court, and they're telling them the date that they're going to be there and when they're leaving, right? If someone is in sheriff custody, they're not allowed to transfer them directly to ICE. So the sheriffs are alerting ICE that we're about to lose custody of this person. They're going to court or they're being released. Come pick them up. And we've seen this. This has been well reported in the newspaper already, but it's worth highlighting that the Worcester County Sheriff's Office proactively contacts ICE to inform them of individuals in their custody who they might be interested in. There are reports of ICE having access to the building and moving around in our county sheriff facilities. The Berkshire County Sheriff's ICE detainer policy says that whenever they have an inmate who has a pending ICE detainer and they know they're going to be released, we should attempt to notify ICE in advance. Um, but it's not all of them. Bristol County Sheriff recently updated their policy, whereas whereas earlier in 2025, they were sending their daily booking list of all commits every morning. Now they treat requests from ICE as public records requests, sort of the same as if you and I were asking for information. It doesn't guarantee they're not going to send the information, but it's at least a change in policy and shows that some level of leadership there. This information sharing goes well beyond information that's publicly available and includes the sharing of information that's not required by law. And again, almost all of the sheriffs in the Commonwealth are engaging in this. And there's at the Trust Act hearing in March, I guess it was. We basically heard the sheriff saying, yeah, we do this and we think this is a good idea. And again, we have to go to this question of who should decide when information should go to ICE. Who gets to decide that a case where someone is charged with wrongdoing should have their case essentially ended by getting detained and deported. And if someone's case is if someone is deported, that means the victim of the crime is not going to be able to seek justice through the courts. It means that the all of the rights to an attorney, the rights to face your accuser, all of those things get undermined, short-circuited by this decision to share information with ICE. I'll also just mention that several of the sheriff's departments are hiding behind a federal regulation to not provide information, and CfJJ is currently involved in litigation against 4 of them. If you want more information of that, happy to talk about it after. The trial court. We shared recently that more than 700 ICE arrests took place from state courthouses between January 2025 and February 2026. And that's because the trial court policy allows both ICE to enter the court facilities and allows court employees. It doesn't allow court employees to just on their own share information, but if asked, court employees are allowed to share information with ICE about individuals. And that led to 700 arrests. And there have been some really appalling video around. And this is sometimes people who are accused of a crime, but also sometimes they're family members or victims or witnesses. And the trial court doesn't have to do this, right? Other states, our neighbor to the south in Connecticut, Oregon, New Jersey, they have enacted rules that limit ICE activities in the courthouses. And our trial court has refused to do that, even under some pressure. And oddly, they came out in favor of the Protect Act language that would constrain their ICE's actions in courthouses. So I'm a little confused by that, but I also want to say that there's certainly room for strengthening their policy on their own, and they don't need to wait for the legislature. Okay, I'm going to move on to some recommendations, a few general recommendations, and then some things for specific entities. The general recommendations are that it's really up to us and up to our agencies to defend our state level justice system institutions, right? Everyone deserves to have a day in court and to be presumed innocent until proven guilty. We should not allow our local justice actors to alert ICE to individuals' whereabouts because this is a short circuit of the legal process that everyone is entitled to. Um, Broadly, our justice system is being co-opted, as I said, and being used as a force multiplier. And it's up to those agencies themselves, in the interest of justice, to resist this preemptive obedience to an authoritarian regime. Secondly, we should avoid policies that further this false good immigrant, bad immigrant narrative. Federal authorities right now are painting entire communities of color as bad immigrants who need to be deported. And we should resist that actively. ICE is posted in courthouses, outside schools, workplaces, and community centers, which is causing fear. And even if someone is accused of wrongdoing, we have a state justice system that is meant to deal with that. It's not up to our individual actors to say, well, this is someone who's bad. It's our decision to alert ICE to their whereabouts and get them deported. Our recommendation to the legislature is absolutely to adopt and protect and expand the Protect Act and provide stronger guardrails. And this is one step in a process. We're very hopeful. The House passed their version of Protect Act several weeks ago. The Senate version was released last evening, and I haven't had a chance to go through it. But you'll be hearing about this this week, so this is very timely. One of the things that is missing, as I mentioned, is any mention of fingerprinting in either of the versions. And we think it's really important to include stricter fingerprinting re regulation that police don't need to fingerprint unless specifically required by law. And even, like has been done in Illinois, not require that juvenile fingerprints be sent to the FBI at all, right? If you're checking for a warrant, out-of-state warrant, they're kids. They probably don't have one. And the risk of alerting the federal authorities to this person's whereabout can and does lead to their detention within ICE. And we have some bills mentioned here, House 1657, Senate 1058, that would do just that. There is a need to enact limits to the sheriffs and local law enforcement on information sharing with ICE, and again to treat ICE requests like public records. There were some carve-outs in the House version of the Protect Act regarding Chapter 265 that we have some concerns about. And there's room for further study of municipal participation in federal policing task forces, including the ICE HSI task force. We also need increased guardrails on police surveillance technology. And it is time to really comprehensively rethink the use of gang databases and consider abolishing them, given the documented racial disparities and civil liberties violations, and at the very least, add some guardrails. We should also, the legislature should also limit the use of license plate readers as well as facial surveillance technology. And certainly the information sharing elements of that with the federal agencies. As I mentioned, the trial court should enact its own rules to limit ICE and courthouse and the sharing of non-public information. And the governor should cancel the 287G agreement, the 287G agreement between Massachusetts DOC and ICE, right? The Massachusetts is the only democratically controlled state in the country that has an active statewide 287G agreement. And the current House version that passed has a carve out that allows this to continue. My concern with having that be still in place is that it would by removing it would send a clear signal statewide that Massachusetts refuses to act as a force multiplier. And I've had an elected sheriff tell me, look, we're just doing what the governor's doing. So um, it would be setting a good example for our county level carceral institutions. And action is also possible at the municipal and county level, right? Municipalities and county sheriffs should be setting clear guidelines limiting ICE collaboration information sharing, as well as setting similar guidelines and limitations on license plate reader use and surveillance technology. Um, the police departments should review and revise their existing immigration policies to make sure that at the least they comply with state law, including the Lund decision, and have strong officer accountability for violations. Um, and finally, that the AGO and the Post Commission should really look into accountability and oversight for this question. Um, I've gone longer than I wanted, so I'm going to just move forward. Just to say, this is not just about immigration. It's also about our democracy overall. And if our local police officers and institutions are buddied up with ICE in immigration, it's going to be much harder to disentangle these entities if and when ICE is called out to monitor local elections in November, right? So my parting note here is that Timothy Snyder's on Tyranny, 20 Lessons from the 20th Century says, be wary of paramilitaries, right? When a pro-leader paramilitary and official police and military intermingle, the end has come. There's an appendix in the report that is an advocate's toolkit that sort of presents all that we have and lets you see the data and the policies that we've collected and encourages people to analyze for immigration enforcement policies for local change. And hopefully that can be updated if and when the Protect Act it passes. Thank you so much. I really appreciate your time, and I'll pass it back to Leon.
Josh, thank you so much. Just for that deep research, but also just how hard you have worked just for everyone's benefit. Josh has been burning the midnight oil, not only to put this together, but to put this together in a timely fashion so that it could be available at a time when our legislators are currently considering some of these issues. Very quickly before we pivot to our next speaker, we embarked on this research journey in support and allyship with our immigrant friends, neighbors, and allies who were already raising their voices about the terror they felt in their own communities right here in Massachusetts. So we submit this report not just for our policymakers, but in affirmation in support of those voices in our immigrant communities. And we felt that it was necessary because even into late last year, we still heard reticence and skepticism from some in power that these things were even happening, or that the harm was as deep as we clearly saw in conversation with our immigrant friends and neighbors. And so this is our statement that yes, these things are happening right here, even in exceptional Massachusetts, and that change needs to be done in order to protect our immigrant friends and neighbors. And with that, I will shift to an amazing organization that has organized those directly impacted voices and really led the way in the call for reform to address these harms of ICE. Gail Calderine, who works with MIRA, the Massachusetts Immigrant and Refugee Advocacy Coalition. He is their director of advocacy, and he will talk about MIRA's work and just really the amazing work that they're doing through their Protecting Mass Communities or PMC coalition. Gil, I turn it over to you.
Thank you so much, Leon, and good afternoon, everyone. It's so good to see you all. I see a lot of familiar faces. Gail Calderon, Director of Advocacy at the MIRA Coalition. And I just want to first start by thanking CfJJ for the work on this report. It confirms what many of us have known for quite some time, and that is truly that local police, sheriffs, and courthouse staff are regularly collaborating with federal immigration authorities. They're sharing information and, in effect, acting as force multipliers to ICE, as Josh mentioned in his report. For a long time, some elected officials were not even convinced that this was happening here in our own backyards or in their own districts. And I think what this report does, it makes that reality undeniable. It brings forward clear evidence that this is in fact happening right here in Massachusetts, and they can no longer run away from that information. And if we're serious about keeping people in Massachusetts safe, especially our immigrant and refugee neighbors, then we need to make sure that local law enforcement is not collaborating with ICE or sharing sensitive information about individuals. That's why we're calling on the legislature to immediately end this type of information sharing and to take the steps to, protect communities. Because here's what's at stake, folks. When people are afraid that any interaction with law enforcement could lead to federal immigration consequences, then they stop coming forward. It's just a fact. They become less likely to report crimes and they're less likely to cooperate with investigations. And, oftentimes this gets lost out of the conversation is that many families lived in mixed status households. So when something happens, whether they are a victim or a witness, they have to really stop and think for themselves and say, will speaking up put me or my family at risk? And too often that fear keeps people silent. You may have seen the recent public hearing on the Protect Act, where Representative Judith Garcia from Chelsea brought forward a constituent whose daughter, and I'm sorry for using some violent language here, but they were raped. And yet that family is afraid to go to court because they fear being taken by ICE. And that's just not justice. And unfortunately, that fear is not unfounded. When we see reports that well over 600 people have been arrested in courts, it really reinforces exactly why families feel this way, or when they know that local law enforcement agencies like police departments and sheriffs are sharing this type of information. That's a break of the trust. That exist. So Mira, as part of the Protecting Massachusetts Communities campaign, in this round of advocacy, at least with the Senate, we've been asking for several things, and one of them, and I'll be brief because I know folks have a lot of questions for Josh regarding, the report here, but it's to spell out limitations on the specific kinds of collaboration with ICE. Why is this important? The House language right now depends on one broad phrase to do a lot of work, and it simply says state and local resources may not be used for the purpose of an immigration enforcement action. Other states have identified and enumerate the specific forms of assistance that ICE is not allowed to do, and that gives clear guidance to law enforcement and residents about what is prohibited and what is allowed. And I think that's very important for law enforcement to say, yeah, we can't do that. And it's also easy for us as educators, as advocates in our communities to also point directly to those guidelines. So I believe that a lot of the recommendations, that Josh put forth can really fit into this category where the legislature can spell out what is not allowed for that clear guidance and not let it be too broad because that may cause a difference in interpretation, et cetera. The other point that I'll raise is the limitations on law enforcement communication, with immigration agencies must go both ways. Right now the House version allows for law enforcement agencies to respond, to inquiries from ICE, but they can't initiate it, right? And I think it's important that we close, the complete loophole there so that there is no communication on both sides, right? We don't want the situation where ICE can email or start, phone banking in the morning, asking, our local law enforcement, hey, who do you have today? Who are you going to release today? Et cetera. So we want to shut that communication out as well. And it fits into the recommendation, that CfJJ put, together here. The third point here is we're asking for a clean ban on 287G. 10 other states have outright banned 287G contracts without having to create an exception. And we believe that there is value in a clear statement of purpose in that. And then the last point, or the last 2 points here, is banning, law enforcement asking about immigration status with no carve-outs or exceptions. And I think that's important because this prohibition is at the heart of creating trust with immigrant communities. We want community members to feel safe coming forward to law enforcement, and carve-outs or exceptions, however well-intentioned they may be, that does undermine trust. And folks, although I say, law enforcement, for a lot of individuals, 911, yes, we know that 911 is, for an ambulance, it is, for the police department and other, related matters, but folks associate 911 directly with police, and that causes a spillover effect for some other, emergency services that folks may need. So making sure that immigration status isn't asked about. And then the last point here is we want to ban civil arrests in courthouses. The House version is only included in the interior of the courts. We would love to see the exterior of the courts. And I know that there are other advocate groups proposing additional, important information to strengthen this particular provision. And I'll end it with this. I'll just say whatever doesn't make it into the Protect Act this round, I think that the proposal and the report that CfJJ put out is a good roadmap for what we can do in terms of advocacy at a municipal level, and what that roadmap should be for the next legislative cycle, and continue, to roll up our sleeves and get back in the fight. The work isn't done, and it won't be done for a while. So we have our work cut out for ourselves. So Leon and Josh, thank you so much for this report, and I'll turn it back over to you.
Yeah, thank you so much for being here, for sharing those powerful words, and just for all that you all at Mira do. And I just want to uplift your message around the urgency and importance of getting something legislatively done before we pivot to Q&A. I want to share a story that was sent to me last week on why this is so important. On Friday, right here in Boston, the South Boston District Court, an immigrant young man came to court on a charge of unlicensed operation of a scooter. This is an offense under Chapter 90, Section 1E that is punishable by a fine of $25. As low level as can be. This is a young man who was arrested the night before, released on his own recognizance, and showing up for the type of offense that generally gets resolved with the payment of a fine. That young man arrived at court with his infant daughter and his significant other, and he was attacked in the courthouse by ICE. He was attacked, thrown to the ground. His daughter was ripped out of his arm, and he was dragged out of court right here in Boston, while his significant other and his daughter screamed. 3 months after, our governor signed an executive order right here in this city, right here in one of our courts, a place that should be a safe space, a place where people can get justice. This happened. So this is still happening. I have no patience or tolerance for anybody whose head is so stuck in a cloud of exceptionalism that believe that this isn't happening here, because it is still happening now. And we need these actions right now. So with that, I will close out the formal part of our presentation, and I'm happy for to move to Q&A. And Josh, the first question that we have in Q&A is, will the source content embedded in the report be available? There are some folks in local communities who want to really dive in on what's happening in their local communities.
Yeah, absolutely. The report is up, and the final page of the report is a link. There's a link to the what we call the Advocates Toolkit, and in that toolkit is the policies that we've have there. We didn't put everything up in that, just because some of the back and forth, you can get lost in lots of documents. It's like back and forth emails, but I'm welcome to share. We consider these public records, and we're really encouraged by interest in taking action at the local level.
Yeah, so not a question, Josh, but you mentioned it, but there was affirmation around the need to get rid of flock cameras. Did you want to add anything else to that piece that you touched on in the report?
I mean, Flock is just one company. There are other companies who are providing these automatic license plate reader um, technology, and there's a lot that goes in here. There's a question of, should this be used? And then there's a question of, well, how should it be used, and where should the information be available, and under what circumstances, if a municipality decides to use automatic license plate readers, who has access to that data, and is it part of a sort of national network that includes the federal government? And if so, why? So it's not just yes or no, it's also the details of what happens with that information sharing.
Yeah, another question that came in was just sort of so many sheriffs and police departments are openly violating the SJC decision in Lund.
Well, I don't think the sheriffs are necessarily violating LUN. I think that what they're doing is within the is allowed under LUN. Look, I'm not their lawyer. I'm hoping that they considered it and are have come to that conclusion. But I think the problem is all of this information sharing that we talked about from the sheriffs to ICE is happening in spite of LUN. It's happening even though LUN is in place. It shows that their LUN is only covering one very small thing. It does not cover, and it's really for the legislature to close that gap. And it's happening even though there is no 287G agreement between any of the sheriffs and ICE or any of the police departments. So the 287G agreement language in the PROTECT Act is important. And it should be, as I mentioned before, in my opinion, expanded to include the one current 287G with DOC. But that's not enough, right? There's a lot of information sharing going on right now that is currently allowed under Massachusetts law. And so the question is that something that we want to continue to be allowed? Do we want to be a state that allows our local entities to be force multipliers for ICE?
Yeah, no, thank you so much for that, Josh. And it's a reminder that even when we do have favorable court precedent, it's important to take those principles from the courts and still codify them in law. Gil, I'm going to shift the next question to you. Are there any state level actions we can take, and any state level groups going on? That reminds me directly of what you all are doing with PMC.
Yeah, absolutely. There's still ways to get involved, as Josh, mentioned. The Senate version of the Protect Out came out yesterday. I can't comment or provide any further information because our group is still, analyzing it to see the differences there. But it's still not too late to get involved, right? I think if you've learned anything from here today, I would suggest, calling your elected officials and let them know, especially as they're going to vote on this bill, I believe, next week. Right. And I think it's important to get in any last minute, phone calls in or emails in, right? Whatever didn't make it into the Senate version, there's still opportunity through amendments, right? So if your organization or your group is advocating for one particular thing, identify an elected official that can work with you to, potentially introduce an amendment. You can get involved with the PMC. We have action alerts out there, and I know that there are other groups out there, doing similar work. So identify them too, get involved in that way.
Thank you so much, Gil. Erica Perez, I see your hand is raised. Go ahead. And need to unmute
Hi.
Erica.
Yes, I needed permission to be on mute. So my name is Erika Perez, and I'm with Neighbors United for a Better East Boston. So I really appreciate all of this information. It's very important right now. The Senate just put the proposal yesterday, and there's a deadline by 3 p.m. on Monday if we want to file any amendment. So I encourage all of you, if you have lawyers, and if you want to just pick like one section rather than the proposal, the docket in its entirety. So we're working very diligent. I think Josh is working with Fatima on that. But also, I feel like some organizations, we fall into the good and bad immigrant or more deserving than others. So it's a very important that immigration to have that in mind, This is dehumanizing everybody. Just because you have a misdemeanor, and there are a lot of organizations out there that they're called pro-immigrant, but for me, they're not pro-immigrant. They're damaging more. The Black people struggle, the poor people struggle, immigrants struggle. So if I encourage you, we have a platform. It's called the People's Protect Act platform. If you go there, you will see our demands, and we're working closely with some of our allies to file amendments by Monday, 3 p.m. So now we need to find more progressive senators who are willing to listen to this. They're coming after everybody, not just, we know this. That's the history of the US. They target one community, then they will come in after every single one of us in every single way. So if that's why everyone wants to like continue, then keep sitting down. But it's time to call your legislator right now, your senators, because then they're going to vote by Thursday. So the amendment
Yeah.
needs to be filed before 3 p.m. And then we need to keep putting pressure on that. And I'm not even afraid. I spend a lot of time at the State House, and I can't speak in public a lot, but there's a lot of work we can do behind the scenes, and then there will be reconciling on that. But I think thank you so much to all of you for doing this report. It's needed. I think my sister will be speaking at May Day today in Lynn, so it was right on time. Thank you. So we can cite that stuff in Salem and Lynn.
Yes.
Thank you.
No, thank you so much just for your courage and your voice, and for chiming in and for being here with us today. It's voices like yours, which is why we embarked on doing this research in the first place. And an important reminder, the Monday deadline, everyone on this call has an elected official. And we need to remind our elected officials that not just your actions, but your inaction. We will hold you accountable for it. You are not a king. You are here to represent the people. So if you are a constituent, reach out to your elected official and demand that they not only just pass something, but pass something intensive that really, this is not about legislators getting a political win. This is about them moving something that will meaningfully protect our immigrant friends and neighbors, and making that impression upon them is really, really important. Speaking of elected officials, another question, Josh, is what should people be asking of their local district attorneys?
Yeah, thanks so much. Yeah, I didn't get very much data back from district attorneys, although there were a couple of concerning pieces of information that we did get back. Um, some, including a couple of ADAs and staff from district attorney offices specifically sharing information with ICE. So if they alerting ICE to someone's presence and where they'll be, and even asking for them to be arrested. We saw that from an example from Hampden County District Attorney's Office, and there was a case last year in Suffolk County that it appeared that the ADA had called ICE, and so that there's a real question there, right? These are the DA's offices and the ADAs are court officers, and it goes back to that same question, right? Who should be alerting, if anyone, and under what circumstances should members of and professionals in our justice system be calling ICE? I don't think it's appropriate for an ADA to be alerting ICE if they have a case. Their role is to try to seek justice using the Massachusetts justice system. Their role is not to alert outside parties that then, especially if they know that's going to have someone be pulled into detention out of state and potentially deported. So what should we be asking? We should be asking, what's your policy? What's your practice? And I will say some of the elected DAs have come out in favor of the PROTECT Act because they've seen, as we've mentioned a couple of times, that many people in the immigrant community are scared to come to court, and that doesn't help
Yeah.
anyone. So, ask them there to support the PROTECT Act, and ask them what their position is. And to some of their credit, they have done so.
Absolutely. So, quick acknowledgement of a comment. Barry Ingber says that Medford does have a policy limiting collaboration with ICE. Barry, we will follow up with you on that. And now we'll move to the next question from Ashley, who says, who or what makes the decision about whether trial courts allow ICE detainers in the courthouses? In other words, where do these policies come from?
Yeah, I mean, the trial court has in its inherent authority to make its own trial court rules, and their rules are public facing, and they have a specific policy on sort of how to interact with ICE. Um, they have said publicly and in the media that they are using I think they use the word soft diplomacy with ICE. That for them, maintaining a relationship with ICE was important, and in their words, that they were that soft diplomacy helped stop ICE having access to their courtrooms. I find that very hard to believe, given that they also said that 750 plus people were arrested by ICE from their courtrooms, and that we've seen other states have more restrictive policies. So uh, and again, I'm a little confused why they then also came out in favor of the Protect Act, kind of at the last minute. Maybe they were reading the political winds and did not want to be on the wrong side of history. And once it was clear something was going to pass, they came out. But I can't speak for them, and I see no reason why, even in the intervening time, they did not update their rules. And shout out to Lawyers for Civil Rights for really pushing them on this, and a huge shout out to the Luce Network, who has been documenting and supporting people in courthouses around the state and protesting this question and really bringing attention to it. And I mean, big shout out to Luce Network for a lot of reasons, but certainly for this one as well.
No, thank you for that, Josh. On a human level, if you are friendly with someone who is openly hateful and harmful and hostile towards me, I'm not going to trust you because you are friendly with those who are posing harm. That is simply common sense and human nature. So I too was bothered by that sort of soft diplomacy because we don't need soft diplomacy. We need limits and restrictions on harm right now. I don't see anything else in the chat. Are there any other questions? We want to make sure we get to any questions before we close. Seeing none, I want to just, oh, Erica, I think you had another question. Please go ahead. Oh, we can unmute Erica.
Thank you. Um, so my question is, have you seen any other legislation around the country to like stop the collaboration between, this like task forces, fusion centers,
Mhm.
and data sharing, that it's easier now, just like 287. I know that it's 10 states that have a ban 287Gs around the country. So it's easy, like once one state has passed something, to build off of that or to modify it. Given to this very quickly deadline, is like we need someone, or who else does have this language ready to share, so people can continue drafting on that and make at least, they may not pass something meaningful, but I feel like it's a good start to start talking about this. So I don't know if any
So-
of you know anyone around the country. Has it been like movement around that, or this is something new here in Massachusetts?
No, thank you
We
for
can
your
start in
question, Josh.
Massachusetts and maybe expand it around the country.
No, absolutely. Josh, Gil, are you aware of any, as it relates to these massive data sharing networks and fusion centers, is there any guidance that we have nationally?
Um, I think there is some, and I don't know, I don't have it at the top of my head, so I'm not going to answer. I don't know.
But it's something good for us to definitely look
Yeah,
into.
we'll look into it.
I'm not
My,
aware either, so I apologize.
yeah. Thank you, Erica. You've given us all some homework.
There was a question I saw on how to influence the trial court and who makes the decision. Letters to the Chief Justice of the trial court, and potentially also to the Governor's Council, just in terms of agencies. And yeah, that might be the way. The
yeah.
judges don't like to be told what to do very much, so that can be challenging.
but raise your voices anyway. Michael Berger, go ahead.
Hi, thank you so much for all of this. This is so helpful, so important. So am I correct in understanding that as long as there is no direct detainer request to a department or an agency, then they're fully within their rights under Lund to reach out to ICE to share like whatever they want, whenever they want?
I mean, my reading, whether or not there's a detainer request in place, my reading is that uh, local and county level agencies that are can talk with ICE if they want to. So there right now there are not limitations in our from our state law on that communication.
Right. Okay. So Lund is only bars the holding of someone strictly based on that detainer request, but everything else is fair game.
Correct. Yeah, Lund says
That is correct.
uh, if ICE asks you to hold on to someone after you are going to release them, you can't do that. You need to have a state law reason for holding someone in custody. But I think it's an important thing to just note here, right? This is really challenging for law enforcement people to hear. All of this is challenging for law enforcement people to hear because there's this like I'll call it a bro code of like law enforcement agencies want to work together with their sister agencies. Well, now I use both brothers and sisters in the same sentence here. But since after 9/11, there's been this huge push to have local law enforcement work together with state law enforcement, work together with national law enforcement, and a lot of these task forces were set up to sort of facilitate these relationships and facilitate the information sharing and the fingerprinting process that started sort of as in I think 2008, 2009 to have a national fingerprint database that is secure communities was the what it was named. We're now saying actually law enforcement careful, the feds are not acting in constitutional ways. And now the local law enforcement are like, whoa, well, what, first of all, they're like not sure what they're supposed to do, but also they have these relationships. This is our, the fellow law enforcement. And we're saying this is a moment to really rethink the relationship with federal law enforcement and consider decoupling for immigration purposes, but also for sort of broader democratic purposes, what have been the norms of those relationships.
Thank you so much. Uplifting a few comments in the chat. Thank you so much to Mario. It appears that both California and our New England neighbors in Maine may be a source to look at some proposed legislation. Thank you so much to our good friend Lisa Thoreau for mentioning our colleagues at the ACLU who have been focusing on fusion centers, which are problematic for a number of reasons since their inception as well. Yeah, we are winding down. So one last call for questions. All right, with that, I would just again remind everyone, and these links are in the chat, please go check out the report on CfJJ's website, cfjj.org/ice-out. This recording will be available on our YouTube page shortly. I know some folks came in after it started. And for those who couldn't be here, please share. If you're talking to folks who are considering reaching out to their legislators before Monday and that deadline, please share. At CfJJ, our mantra is we release research to drive change, not research for research's sake. So we really want this to be instrumental and a part of the change that we're seeking. But with that being said, I want to thank all of you all. Thank you, Gil, so much for being here. Again, major kudos to you, Josh, for your hard work. And thank all of you for coming here in support and solidarity. We appreciate you all. Thank you very much and have a great rest of your day.